Welcome to another AS and A-level law revision session. In this video, we will be exploring police powers in England and Wales, an important topic within the study of the legal system and criminal justice process. Police powers are essential because they determine the extent to which the police may interfere with individual rights and freedoms in order to prevent crime, investigate offenses, and maintain public order. At the same time, the law also places limits on these powers to protect citizens from abuse and ensure accountability. Throughout this topic, we will examine the main powers granted to the police under legislation such as the Police and Criminal Evidence Act 1984, commonly known as PACE, together with its codes of practice. We will look at powers including stop and search, arrest, detention, questioning, searches at police stations, fingerprinting, and the taking of samples. We will also consider the safeguards available to suspects and the balance the law tries to achieve between effective law enforcement and the protection of civil liberties. By the end of this revision session, you should be able to explain the main police powers, identify the legal rules governing them, and evaluate how effectively the law balances police authority with individual rights. To understand police powers in England and Wales, we must first recognize the central conflict at the heart of this area of law. On one side, the state requires effective investigative powers to prevent crime, maintain public order, and protect society. On the other side, individuals possess fundamental rights to liberty, privacy, and freedom from unnecessary interference in their daily lives. Inevitably, these two interests can come into conflict. In practice, police officers operate within an extremely demanding and complex environment. Their responsibilities extend far beyond simply dealing with criminal offenses. Officers regularly manage domestic disputes, vulnerable individuals, public disorder, community tensions, and threats to public safety, often under significant pressure and within rapidly changing situations. Because police powers involve the ability of the state to interfere with personal freedom, the law imposes important constitutional safeguards. Statutory legislation, particularly the Police and Criminal Evidence Act 1984, together with detailed codes of practice, exist to regulate how these powers are exercised. These legal controls are designed to prevent arbitrary or abusive use of authority, while still allowing the police to carry out effective investigations. In this way, the law attempts to balance the needs of law enforcement with the protection of individual rights and civil liberties. Police powers in England and Wales are built upon two major statutory foundations. The first is the Police and Criminal Evidence Act 1984, commonly known as PACE. This is the core framework governing police powers and procedures. It establishes important powers such as stop and search, arrest, detention, questioning, searches, and the taking of fingerprints and samples. PACE is also supported by detailed codes of practice, which regulate how officers must exercise these powers fairly and lawfully. The second major pillar is the Criminal Justice and Public Order Act 1994. This act expanded and modified several police powers, particularly in relation to public order and criminal investigations. It is especially significant because it changed the law concerning the right to silence, allowing courts in some situations to draw adverse inferences from a suspect's silence during questioning. Police powers are not static. Parliament regularly updates legislation to respond to changing forms of crime, terrorism, technology, and public safety concerns. This means the law in this area is constantly evolving. For example, the Criminal Justice Act 2003 introduced broader arrest powers, changes to bail procedures, and reforms affecting criminal prosecutions. The various terrorism acts, including legislation passed in 2006 and 2011, created special rules relating to terrorism investigations, such as extended detention periods and preventative control measures. In addition, the Police Reform and Social Responsibility Act 2011 introduced reforms aimed at strengthening police accountability and restructuring oversight mechanisms. At the same time, modern police powers face increasing scrutiny under the Human Rights Act 1998. Courts frequently examine whether police actions interfere excessively with individual rights such as liberty, privacy, freedom of expression, and freedom of assembly. This area of law also connects closely with public order and public safety topics studied later in the syllabus, demonstrating how police powers operate at the intersection of criminal justice, civil liberties, and state authority. To fully understand modern police powers, it is important to examine the historical background that led to the creation of the current system. Originally, many police powers were based on common law principles rather than detailed statutory rules. This created uncertainty because powers were often vague, inconsistent, and heavily dependent on police discretion. Public concern increased significantly during the 20th century, particularly because of the use of the old sus laws derived from historic vagrancy legislation. These laws allowed police to stop, search, and arrest individuals merely on suspicion of intending to commit an offense. The powers were widely criticized for discriminatory and excessive use, especially against Black communities. Tensions surrounding these practices contributed to the 1981 Brixton riots. At the same time, several miscarriages of justice raised concerns about police procedures, treatment of suspects, and reliability of evidence. In response, the government established the Royal Commission on Criminal Procedure in 1981 to review and reform the criminal investigation process. These developments eventually led to the creation of the Police and Criminal Evidence Act, 1984. The central purpose of PACE was to create a balance between effective law enforcement and the protection of individual liberties. PACE achieved this by codifying police powers, meaning that powers previously scattered across common law and different statutes were clearly defined within one legal framework. At the same time, the Act introduced safeguards designed to protect suspects from abuse of authority. An important feature of PACE is its codes of practice. These are detailed administrative guidelines explaining how police powers should be exercised in practice. Although the codes themselves are not strictly laws, failure to follow them can have serious consequences. Officers may face disciplinary action, and evidence obtained in breach of the codes may be excluded by the court during trial proceedings. Modern police powers therefore operate according to three important principles: reasonableness, proportionality, and accountability. Police actions must be justified, proportionate to the situation, and capable of being reviewed or challenged. Within this framework, PACE grants police several key operational powers, including the powers to stop and search, arrest suspects, detain individuals, conduct interviews, and carry out criminal investigations. Stop and search powers are among the most controversial powers exercised by police officers in England and Wales. Historically, these powers were heavily criticized because they were often used disproportionately against particular communities, creating allegations of discrimination, racial profiling, and misuse of police discretion. This historical background explains why stop and search remains subject to intense legal and public scrutiny today. The intrusive nature of the power is another reason for this controversy. A stop and search allows police officers to stop individuals in public spaces, question them, and physically search their person, clothing, bags, or vehicles. Because this directly interferes with personal liberty and privacy, the law imposes important safeguards and restrictions on how the power may be exercised. The main legal basis for ordinary stop and search powers is found in Sections 1 and 2 of the Police and Criminal Evidence Act, 1984. These provisions give constables authority to search persons or vehicles in public places where there are lawful grounds to do so. Additional legislation creates specialized forms of stop and search powers. The Misuse of Drugs Act, 1971, permits targeted searches for controlled drugs and narcotics. The Terrorism Act, 2000, provides enhanced search powers connected to counterterrorism operations and national security concerns. The Criminal Justice and Public Order Act, 1994, also grants wider search powers relating to public safety and designated areas. A key legal safeguard is the requirement for reasonable suspicion. Officers must possess objective and reasonable grounds before carrying out a search. Suspicion cannot be based on vague assumptions or personal instinct alone. It must be connected to specific facts, intelligence, behavior, or surrounding circumstances. The law also expressly prohibits arbitrary and discriminatory searches. Police officers must not base suspicion solely on factors such as race, ethnicity, hairstyle, age, clothing style, or general appearance. These anti-discrimination rules were developed in response to historical concerns about abuse of stop and search powers. The purpose of these searches is to locate prohibited articles. These include offensive weapons, stolen property, burglary tools, or items adapted for theft-related offenses. Amendments introduced under the Criminal Justice Act, 2003, extended the list further, by including items intended for criminal damage. For example, an officer may lawfully stop and search a person carrying spray paint canisters if there are reasonable grounds to suspect that the items are intended for graffiti-related criminal damage. Because stop and search powers involve a direct interference with personal liberty, the law requires officers to follow strict procedural safeguards before any search can begin. One of the most important safeguards is the requirement known as go wisely. Before conducting a search, officers must clearly communicate specific information to the individual involved. First, they must explain the grounds for the search, meaning the reasons why they suspect prohibited items may be present. Second, they must state the object of the search, in other words, what they are actually looking for, such as drugs, weapons, or stolen goods. Third, if the officer is not in uniform, they must produce their warrant card as proof of police authority. The officer must also provide their identity and specify the police station to which they are attached. In addition, the individual must be informed of their entitlement to receive a copy of the search record. The officer must further identify the legal power being used for the search, and clearly inform the person that they are being detained for the purpose of a search. These requirements exist to ensure transparency, accountability, and protection against arbitrary use of police powers. Failure to comply with these safeguards may make the search unlawful. The law also imposes important limits on how searches may be carried out. For example, strip searches are strictly prohibited on public streets and may only take place within a police station under controlled conditions. Recent developments have further expanded police powers. The Public Order Act 2023 introduced additional powers allowing police to search for items intended to be used in causing public nuisance or serious disruption. An important judicial authority in this area is Mustafa Osman v. Southern Crown Court. In this case, the court held that failure by officers to provide their names and police station rendered the search unlawful. The decision demonstrates how strictly courts interpret procedural safeguards surrounding stop and search powers. The judiciary has repeatedly emphasized that stop and search represents a serious interference with individual freedom and dignity. As a result, officers are expected to comply fully with every legal safeguard before exercising the power. These protections also reflect broader constitutional and human rights principles. Under European Convention on Human Rights Article 5.1, every individual has the right to liberty and security of person. Any restriction on physical freedom is only lawful where it is carried out strictly, according to procedures established by law. Another major police power under the law of England and Wales is the power of arrest. Arrest powers are extremely significant because they involve one of the most serious interferences with individual liberty available to the state. For this reason, the law carefully regulates when and how an arrest may occur. There are different categories of arrest authority. The first is arrest with a warrant. A warrant is a written legal authority issued by a magistrate or judge directing police officers to arrest a specifically named individual. Warrants are usually issued where a court is satisfied that legal grounds exist for the arrest. Statutory authority for warrants can be found under Section 1 of the Magistrates' Courts Act, 1980. This provision allows a justice of the peace to issue a warrant for indictable offenses, imprisonable offenses, or situations where the suspect's address cannot be verified. The second category is arrest without a warrant. This power is primarily governed by Section 24 of the Police and Criminal Evidence Act, 1984, which was significantly amended by Section 110 of the Serious Organized Crime and Police Act, 2005. These reforms greatly expanded police powers by allowing officers to arrest without a warrant for any offense, provided the legal conditions are satisfied. In legal terms, an arrest represents a deprivation of an individual's physical freedom of movement. The person is no longer free to leave and becomes subject to police control. An arrest may be carried out either through physical contact or through clear words indicating that the person is under arrest, provided the suspect submits to that authority. In practice, officers often combine verbal communication with physical restraint to ensure control of the situation. Under Section 117 of PACE, police officers may use reasonable force when carrying out an arrest. This can include handcuffs or physical restraint, but only where the force used is rational, necessary, and proportionate to the circumstances. Excessive or unnecessary force may render the arrest unlawful and expose officers to legal consequences. A further safeguard is the necessity test contained in Section 24, subsection 5 of PACE, and explained in Code G of the PACE Codes of Practice. Even where officers possess reasonable suspicion, an arrest will still be unlawful unless it is genuinely necessary for a recognized policing purpose. For example, arrest may be necessary to allow a prompt and effective investigation of the offense, to prevent the suspect from causing injury to themselves or others, to stop the suspect from disappearing, or to protect a child or vulnerable person. The necessity requirement is particularly important because it prevents officers from using arrest powers automatically, where less intrusive alternatives may be available. Because arrest represents such a serious interference with liberty, the law imposes strict procedural requirements that officers must follow at the moment of arrest. First, the suspect must be clearly informed that they are under arrest. The officer must use direct and unambiguous language so that the individual fully understands that their freedom of movement has been restricted by lawful authority. Second, the officer must explain the legal and factual grounds for the arrest. This means the suspect must be told not only the offense involved, but also the reasons why the officer believes arrest is justified in the particular circumstances. The importance of these safeguards was reinforced in Taylor v. Chief Constable of Thames Valley Police, where the courts emphasized the need for officers to communicate arrest grounds properly and clearly. The duty to state reasons for arrest has deep roots in the common law and was firmly established in Christie v. Lichinsky. The central principle from this case is that a suspect must know the true grounds upon which they are being arrested. Without this knowledge, the arrest cannot be regarded as lawful. This principle was later incorporated directly into statute through Section 28 of the Police and Criminal Evidence Act, 1984. Under this provision, officers are legally required to inform the suspect of the grounds for arrest, either at the time of arrest or as soon as reasonably practicable afterwards. Importantly, the requirement applies even where the reasons may appear obvious. The law does not allow officers to assume that a suspect already understands the grounds for arrest. Section 28, subsection 4, specifically reinforces this obligation, making communication of the grounds a mandatory legal safeguard rather than a mere procedural formality. Failure to comply with these requirements can have serious legal consequences. If officers fail to properly inform a suspect of the grounds for arrest, the entire arrest may be declared unlawful by the courts. Before continuing with detention and questioning powers, it is important to examine the legal powers governing the use of force and the common law power of arrest for breach of the peace. The general power to use force is found under Section 3(1) of the Criminal Law Act, 1967. This provision states that a person may use reasonable force in the prevention of crime or in effecting or assisting a lawful arrest. The key legal requirement is reasonableness. Any force used must be proportionate to the circumstances and no greater than necessary. Excessive force may result in criminal liability or civil claims against the individual using it. Importantly, this power applies universally. It is not limited to police officers. Ordinary citizens may also rely on Section 3(1), where the legal conditions are satisfied. Police officers possess an additional statutory power under Section 117 of the Police and Criminal Evidence Act, 1984. This provision allows constables to use reasonable force where necessary in exercising powers granted under PACE, such as arrest, search, or detention powers. Unlike Section 3 of the Criminal Law Act, 1967, Section 117 applies specifically to police officers acting within their statutory duties. Again, the force used must always remain necessary and proportionate to the situation faced by the officer. Alongside these statutory powers, an important common law power of arrest still exists in relation to breaches of the peace. Notably, this is one of the few remaining common law arrest powers that was left largely unaffected by PACE 1984. The power may be exercised both by police officers and by private citizens where the legal conditions are met. This reflects the long-standing common law principle that preserving the peace is a responsibility shared across society. The leading authority in this area is R. v. Howell, where the Court of Appeal established the main criteria governing lawful arrest for breach of the peace. First, an arrest may occur where a breach of the peace is actively taking place in the presence of the arresting person. Second, an arrest may be lawful where the arrestor reasonably believes that a breach of the peace is about to occur in the immediate future, even if violence has not yet begun. Third, an arrest may also be justified where a breach of the peace has already occurred, but there are reasonable grounds to believe that violence or disorder is likely to resume. These principles allow police and, in limited situations, private citizens to intervene preventatively in order to maintain public order and protect public safety. Having examined the common law power of arrest for breach of the peace, it is important to understand exactly what the law means by the term breach of the peace. Legally, a breach of the peace occurs whenever harm is actually done, or is likely to be done, to a person or to property in that person's presence. The concept therefore focuses on threats to public order involving violence or the realistic possibility of violence. The definition also includes a psychological element. A breach of the peace may exist where an individual is placed in genuine fear that such harm is about to occur, even if physical violence has not yet taken place. In practice, breach of the peace powers are commonly associated with incidents such as assaults, affrays, riots, violent disorder, or unlawful assemblies. A critical point is that violence, whether actual or anticipated, is an essential ingredient of the offense. Mere loud behavior, rowdy social gatherings, or boisterous conduct do not automatically amount to a breach of the peace unless there is a genuine threat of violence attached to the situation. Alongside these public order powers, police officers also possess limited authority to detain individuals briefly for questioning before an arrest takes place. This power arises from the general police duty to preserve the peace, prevent crime, and bring offenders to justice. The scope of this principle was examined in Rice v. Connolly. In this case, the court recognized that police officers may make reasonable inquiries and ask questions of members of the public while carrying out their duties. However, the case also established an important safeguard for individual liberty. Members of the public are generally under no legal obligation to answer police questions. A person may lawfully refuse to respond without automatically committing an offense. The court further held that refusal to answer police questions does not by itself amount to willful obstruction of a constable under Section 89 of the Police Act 1996. This principle reinforces the balance within police powers law between effective policing and the preservation of individual freedoms. Once a person has been arrested and taken to a police station, the next legal issue is whether they may continue to be detained against their will. Because detention represents a serious restriction on liberty, the law imposes strict procedural safeguards governing the treatment of suspects in police custody. The main rules are contained in Code C of the Police and Criminal Evidence Act 1984, Codes of Practice. Code C regulates the detention, treatment, and questioning of suspects while they are held at a police station. After arrival at the station, the suspect must first be brought before a custody officer. The investigating officers then continue gathering evidence in order to determine whether the suspect should eventually be charged or released. Under Section 36 of PACE, the custody officer plays a central safeguarding role within the detention process. The custody officer is responsible for overseeing the welfare and legal rights of the detainee throughout their time in custody. To ensure impartiality, the custody officer must hold a rank above sergeant and must not be directly involved in the investigation concerning the suspect. This separation helps prevent abuse of detention powers and ensures independent supervision of the custody process. The custody officer is also responsible for maintaining detailed custody records. These records include the suspect's arrival time, property removed from them, interview times, access to legal advice, and details relating to rest periods, meals, and refreshments. Importantly, detention cannot continue indefinitely without review. The custody officer must review whether detention remains necessary after the first 6 hours and then every 9 hours afterwards. If these reviews are not carried out properly, the detention may become unlawful. During detention, investigators may carry out several investigative procedures. These can include audio-recorded interviews with the suspect, the taking of fingerprints, footwear impressions, identification procedures, and the collection of intimate or non-intimate samples for evidential purposes. Once detention begins, the law requires police officers to formally inform the detainee of the reasons why they are being held. This safeguard is important because a person cannot lawfully be deprived of liberty without understanding the legal basis for that detention. A written custody record must also be created and maintained throughout the detention period. This record acts as an official account of everything that occurs while the suspect is in police custody and provides an important mechanism of accountability. The custody record must include several key details. First, it must record the reason for the arrest itself. Second, it must explain why the custody officer believes continued detention is lawful and necessary. The record must also contain information about the detainee's legal rights, including whether the suspect chose to exercise those rights, such as access to legal advice. If the detainee declines to use their rights, the record must confirm that those rights were clearly explained to them. In addition, details of every review of detention must be recorded. These reviews are essential because police detention must remain continuously justified under the law. The Police and Criminal Evidence Act, 1984, also imposes strict limits on how long suspects may be detained without charge. Under Sections 41 and 42 of PACE, the normal maximum period of detention is 24 hours for indictable offenses. This reflects the principle that suspects should not be held for excessive periods without formal charges being brought. However, detention may be extended up to 36 hours if a superintendent authorizes the extension and believes further detention is necessary for the investigation. In the most serious cases, police may apply to magistrates for a further extension. A magistrate's court may authorize detention for up to a total maximum of 96 hours before the suspect must either be charged or released. These time limits are designed to balance effective criminal investigations with the protection of individual liberty and protection against arbitrary detention. Once a person has been arrested and taken into police custody, the law provides important protections to safeguard their rights and welfare. A detained suspect has the right to consult privately with a solicitor. This ensures they can receive legal advice before or during questioning. They also have the right to have someone informed of their arrest, such as a family member or friend. Where necessary, a suspect is entitled to an interpreter or translator so they can fully understand what is happening and communicate effectively. In addition, the police must clearly explain why the person has been arrested and why they are being detained. The law also protects the suspect's basic living conditions while in custody. They must be given adequate rest, food, and exercise. Cells must be clean, properly ventilated, adequately lit, and heated. If a suspect is injured or suffering from a medical condition, they must receive medical attention from a doctor as soon as possible. Furthermore, where detention lasts longer than 1 day, the suspect must receive at least 8 continuous hours of rest during every 24-hour period. These rights are designed to ensure that police powers are exercised fairly, lawfully, and with respect for human dignity. One of the most important protections available to a detained suspect is the right to legal advice. A suspect has the right to free and independent legal advice from a solicitor or from an accredited police station representative. This advice may be given face-to-face or over the telephone. Importantly, any consultation between the suspect and their legal advisor must be conducted in private. The suspect can request legal advice at any stage while in police custody. However, the police do have a limited power to delay access to legal advice in certain serious situations. This usually applies where allowing immediate access could interfere with the investigation of an indictable offense. For example, access may be delayed if the police believe it could lead to interference with evidence, injury to other persons, warning other suspects who have not yet been arrested, or hindering the recovery of stolen or illegal property connected to the offense. Any delay must be justified and can last for a maximum of 36 hours, but only while those reasons continue to exist. In addition, a detained suspect has the right to request that a relative, friend, or another person is informed of their arrest and whereabouts. Just like the right to legal advice, this communication right may also be delayed in exceptional circumstances where it is necessary to protect evidence or prevent interference with the investigation. These safeguards aim to balance effective policing with the protection of individual rights and freedoms. This slide explains what an interview means in criminal investigations and the rules surrounding recorded interviews. An interview is the questioning of a suspect about their involvement or suspected involvement in a crime. Before the interview begins, the suspect must be cautioned. PACE Code E and Code F provide the rules for recording interviews. Code E deals with audio recordings, while Code F relates to video recordings. Video interviews with sound are usually reserved for more serious offenses or situations where the suspect has a disability, such as requiring a sign language interpreter because of a hearing impairment. There is no fixed rule stating whether an interview must be audio or video recorded, and suspects do not have a legal right to refuse video recording. However, if a suspect objects, their objection should be stated on camera, and the officer will decide whether the interview should continue in that format. Audio interviews are recorded using 3 tapes. The first is the master copy, which is sealed after the interview and only opened for court proceedings. The second is the working copy, which is used to prepare transcripts. The third copy is provided to the suspect or their legal representative. Before conducting the interview, the investigating officer must consider whether the suspect is capable of understanding and answering questions properly. For example, they may be affected by alcohol, drugs, illness, or another condition. In some cases, special arrangements may need to be made to ensure the interview is fair and reliable. Special arrangements must be made during police interviews to ensure that suspects are treated fairly and are able to participate effectively in the process. For juveniles aged between 10 and 16, a parent, guardian, or another responsible adult must be present during the interview. Where a suspect has a mental disability, an appropriate adult is required to attend to safeguard their interests and ensure they understand the proceedings. In cases involving suspects who are deaf, blind, or unable to speak, an appropriate adult or interpreter must be present to assist communication. Similarly, where a suspect cannot speak or fully understand English, a qualified interpreter must be provided throughout the interview. Failure to make these arrangements may result in any evidence obtained during the interview being ruled inadmissible in court. This is because the interview process must remain fair, lawful, and reliable. Investigating officers must also avoid any form of oppressive or inappropriate conduct when questioning suspects. Interviews should not involve intimidation, threats, or unfair pressure in an attempt to obtain answers. Examples of improper behavior include shouting at a suspect, using threatening gestures, or any conduct that could undermine the fairness of the interview. The Criminal Justice and Public Order Act, 1994, introduced a major legislative shift in relation to the right to silence. Prior to this reform, the common law provided broader protection for suspects who chose not to answer police questions. However, the act significantly restricted that protection and created considerable constitutional controversy, as many argued that it weakened a long-standing safeguard within the criminal justice system. Although the right to silence continues to receive protection under the European Convention on Human Rights, the practical reality for suspects has changed considerably. A suspect may still choose to remain silent, but that decision now carries potential legal consequences. Silence during police questioning or at trial can place a suspect at a strategic disadvantage. Under the current framework, a court or jury may draw what is known as an adverse inference from a suspect's silence. This means that the failure to answer questions or provide relevant information may be treated as supporting the prosecution's case. Section 34 of the Criminal Justice and Public Order Act, 1994, specifically allows adverse inferences to be drawn, where a suspect later relies on facts, explanations, or alibis in court that they failed to mention during police questioning. This may include important contextual details that could support an innocent explanation but were not disclosed when the suspect was being officially questioned. As a result, suspects must carefully consider how they respond during police interviews, as remaining completely silent may later weaken their defense during criminal proceedings. Having considered the protections surrounding police interviews and the rights of suspects during questioning, it is also important to examine the powers the police possess once a suspect arrives at the police station. One of the key responsibilities of the custody officer is to ensure safety, preserve evidence, and assess the level of search that may be necessary. Upon arrival at the station, the custody officer records all items in the suspect's possession and determines the appropriate type of search required under the law. The most common form is the routine search under Section 54 of PACE. This involves an inventory search of the suspect's clothing and personal belongings. Police officers may seize items or clothing if they reasonably believe those items could be used to cause injury, damage property, interfere with evidence, or assist the suspect in escaping custody. In more serious circumstances, a strip search may be carried out under Annex A of Code C. A strip search involves the removal of more than outer clothing and can only take place where there are reasonable grounds to suspect that the individual is concealing unauthorized items or evidence. Strict safeguards apply to protect the dignity of the suspect. The search must be conducted privately by an officer of the same sex and away from public view or other detainees. Where the suspect is a juvenile or otherwise vulnerable, an appropriate adult must also be present. The most intrusive form of search is the intimate search under Section 55 of PACE. This involves the physical examination of body orifices, excluding the mouth, and is only permitted in very limited circumstances. Authorization must be given by an officer of at least inspector rank, and there must be reasonable suspicion that the suspect is concealing either a Class A drug intended for supply or export, or a dangerous article capable of causing immediate physical injury. Because of the highly invasive nature of intimate searches, further safeguards are imposed. The search must normally be carried out by a qualified medical practitioner or nurse. Only in exceptional situations where a dangerous article is suspected and medical personnel are unavailable, may an officer of the same sex conduct the search. These rules reflect the continuing balance within criminal procedure between effective policing powers and the protection of individual rights and dignity while in police custody. Alongside the powers of search at the police station, the police may also obtain physical samples from suspects for identification and evidential purposes. Under PACE, these samples are divided into two categories, each with different legal requirements and safeguards. The first category is non-intimate samples under Section 63. These include items such as hair, excluding pubic hair, nail clippings, skin swabs, saliva, and mouth swabs. Where a suspect is lawfully detained or held for a recordable offense, these samples may be taken without the suspect's consent, provided authorization is given by an officer of at least inspector rank. If the suspect refuses, reasonable force may be used to obtain the sample once proper authorization has been granted. The second category is intimate samples under Section 62, which involve a much greater level of bodily intrusion. These include blood, semen, urine, pubic hair, and dental impressions. Because of their highly personal nature, intimate samples can only be taken with the suspect's written consent. If a suspect refuses to provide an intimate sample without a valid reason, Section 62, subsection 10, allows the court or jury to draw adverse inferences from that refusal during trial proceedings. In other words, the refusal may be treated as supporting the prosecution's case. Strict safeguards also apply to the taking of intimate samples. These procedures must normally be carried out by a registered medical practitioner or dentist, with the exception of urine samples. These provisions once again demonstrate the balance within criminal procedure between the investigative powers of the police and the protection of individual rights, privacy, and bodily integrity. Another important identification power available to the police is the taking of fingerprints under Section 61 of PACE. Fingerprints play a significant role in criminal investigations, as they allow police to confirm identity and compare suspects against evidence collected from crime scenes. Where a suspect is lawfully detained at a police station for a recordable offense, the police may take fingerprints without the suspect's consent. This power reflects the importance of fingerprint evidence in modern policing and criminal procedure. In practice, fingerprints are now usually obtained digitally through electronic scanning systems, making the process quicker, more accurate, and easier to store within police databases. If a suspect refuses to cooperate, officers may use reasonable force to obtain the fingerprints, provided the legal power has first been properly explained to the suspect. As with searches and the taking of samples, these powers are subject to procedural safeguards intended to balance effective investigation with the protection of individual rights and dignity while in police custody. An important issue connected to fingerprints and DNA evidence is the question of how long biometric data can legally be retained by the police. The rules governing retention were significantly reformed by the Protection of Freedoms Act 2012 following the European Court of Human Rights decision in S and Marper v. United Kingdom. The court held that the indefinite retention of biometric data belonging to innocent individuals breached the right to privacy under the European Convention on Human Rights. Under the current framework, where an individual is convicted of a recordable offense, the police are permitted to retain their fingerprints and DNA profile indefinitely. This reflects the view that such information may continue to assist future criminal investigations and public protection. Different rules apply where the suspect is not convicted. such as where no charges are brought or the individual is acquitted. In cases involving minor offenses, the biometric data must generally be destroyed immediately. However, for qualifying or more serious offenses, the police may retain fingerprints and DNA for up to 3 years, even without a conviction. This period may be extended for a further 2 years if authorization is granted by a district judge. These rules attempt to balance two competing interests within the criminal justice system: the need for effective crime detection and prevention on one hand, and the protection of privacy and human rights on the other. Having examined the key police powers under PACE and related legislation, it is now necessary to evaluate whether the law achieves an appropriate balance between effective law enforcement and the protection of civil liberties. One of the most debated areas within this discussion is the use of stop and search powers under Section 1 of PACE and Code A. From the perspective of state effectiveness, stop and search is often defended as an essential preventative policing tool. Supporters argue that it allows officers to intervene before crimes escalate, particularly in relation to weapons offenses, drug possession, and street violence. The power is also viewed as a deterrent, discouraging individuals from carrying illegal items in public spaces. In addition, Code A attempts to regulate police conduct by requiring reasonable suspicion before a search can take place. The code specifically states that suspicion cannot be based purely on personal characteristics such as race, age, appearance, or previous criminal history, thereby aiming to prevent arbitrary or discriminatory use of the power. However, from the perspective of individual liberty and human rights, stop and search remains highly controversial. Statistical evidence repeatedly demonstrates that ethnic minority groups are disproportionately targeted by these powers. Critics argue that, despite the safeguards within Code A, subjective judgments and unconscious bias frequently influence police decisions in practice. As a result, many communities perceive stop and search as discriminatory and damaging to public trust in policing. Concerns are further intensified by Section 60 of the Criminal Justice and Public Order Act, 1994, which permits stop and search without the requirement of reasonable suspicion within designated areas. This significantly expands police discretion and has been criticized for weakening an important legal safeguard against arbitrary interference by the state. Another major area of evaluation concerns the powers of arrest under Section 24 of PACE and Code G. Here, the law attempts to balance the need for effective and immediate law enforcement against the fundamental right to personal liberty and freedom from arbitrary detention. From the perspective of state effectiveness, the modern law on arrest provides police officers with broad operational flexibility. Following amendments introduced by the Serious Organized Crime and Police Act, 2005, officers now possess the power to arrest for any offense, including minor summary offenses, provided the arrest is considered necessary. Supporters argue that this flexibility is essential for modern policing because it enables officers to respond quickly in situations involving vulnerable victims, prevent further offending, preserve evidence, or ensure that suspects can be properly investigated. In this sense, the power of arrest is viewed as an important mechanism for maintaining public safety and ensuring the effective administration of justice. However, significant concerns exist regarding the impact of these powers on individual liberty. Code G states clearly that arrest must only be used where it is genuinely necessary rather than simply convenient for the police. Critics argue that in practice, this safeguard is not always strictly followed, and that arrest can become the default response rather than a measure of last resort. The consequences of arrest can also be severe, even before any finding of guilt. An individual may suffer reputational damage, emotional distress, disruption to employment, and social stigma simply from being taken into custody. As a result, critics maintain that any misuse or overuse of arrest powers represents a serious interference with the presumption of innocence and the protection of personal freedom. Another important area in evaluating police powers concerns detention and the rights afforded to suspects while in police custody under Part 4 of PACE, together with Code C and Code E. The law here attempts to balance the needs of effective criminal investigation against the protection of suspects from coercion, unfair treatment, and wrongful confessions. From the perspective of state effectiveness, the detention framework provides police with sufficient time to investigate serious and complex offenses properly. Under the statutory system, detention can be extended in stages, allowing suspects in serious indictable cases to be held for up to 96 hours with appropriate authorization. Supporters argue that this is necessary in modern policing, particularly where investigations involve large volumes of evidence, multiple suspects, or serious risks to public safety. The introduction of mandatory audio, and in some cases, video recording of interviews under Code E, is also viewed as an important safeguard for both suspects and police officers. Recordings create an objective account of the interview process, helping to prevent false allegations of misconduct, while also discouraging oppressive questioning practices or fabricated confessions. However, from the perspective of individual liberty, significant concerns remain regarding the potential for abuse during detention. Although suspects possess important rights under Sections 56 and 58 of PACE, including the right to have someone informed of their detention and the right to legal advice, these protections may be delayed for up to 36 hours in serious cases. Critics argue that this creates opportunities for police to isolate suspects during the most vulnerable stages of detention. The dangers of abusing these powers were highlighted in R. v. Samuel, 1988, where the court emphasized that delays to legal advice must be strictly justified and not used routinely. The case demonstrated the importance of maintaining genuine safeguards against excessive police discretion. Concerns also arise from the psychological impact of prolonged detention itself. Being held in custody for extended periods, often under stressful and isolating conditions, can place considerable pressure on suspects. Critics argue that this environment increases the risk of unreliable admissions or coerced confessions, particularly where individuals are vulnerable, exhausted, or fearful. Another significant area in evaluating police powers concerns the collection and retention of biometric data under Part V of PACE. This area highlights the continuing tension between the needs of effective criminal investigation and the protection of personal privacy and bodily integrity. From the perspective of state effectiveness, biometric evidence such as fingerprints and DNA profiles has become one of the most valuable tools in modern policing. Supporters argue that allowing police to obtain non-intimate samples under Section 63, including mouth swabs and fingerprints, even without consent, ensures that suspects cannot obstruct investigation simply by refusing cooperation. The development of national forensic databases has also greatly improved the ability of police to identify offenders, solve cold cases, and link suspects to crime scenes with greater accuracy. However, serious concerns have been raised regarding the impact of these powers on individual rights and privacy. For many years, police retained fingerprints and DNA profiles indefinitely, even where individuals had been acquitted or never charged with an offense. Critics argued that this treated innocent people as permanent suspects and represented a disproportionate interference with the right to privacy under Article 8 of the European Convention on Human Rights. These concerns were confirmed in S and Marper v. United Kingdom, 2008, where the European Court of Human Rights ruled that the indefinite retention of biometric data belonging to innocent individuals breached Article 8 protections. The decision became a major human rights challenge to police retention powers and forced significant legislative reform. In response, Parliament introduced the Protection of Freedoms Act 2012, which now requires the destruction of biometric data belonging to innocent individuals involved in minor offenses. This reform is widely regarded as an important victory for civil liberties because it introduced greater safeguards against excessive state intrusion into private life. Ultimately, the strongest protection for individual liberty within the PACE framework lies in judicial oversight and the ability of the courts to control police misconduct. The most important safeguard is found in Section 78 of PACE, which grants judges the discretionary power to exclude evidence where its admission would negatively affect the fairness of the proceedings. This means that if police officers exceed their lawful powers, for example, by conducting an unlawful search, denying access to legal advice, or obtaining evidence unfairly, the court may refuse to admit that evidence at trial. In practical terms, this acts as a powerful check on police authority because evidence obtained improperly may become useless to the prosecution. Overall, PACE 1984 represents a significant attempt to strike a balance between two competing objectives within the criminal justice system. On one hand, The law equips police with broad powers necessary for effective crime prevention, investigation, and public protection. On the other hand, it introduces procedural safeguards designed to protect suspects from arbitrary treatment, coercion, and abuse of state power. Throughout areas such as stop and search, arrest, detention, interviews, searches, and the taking of biometric evidence, the law consistently attempts to balance state efficiency with the preservation of individual rights and civil liberties. However, this balance remains delicate. Critics argue that many police powers have gradually expanded over time, increasing the risk of disproportionate interference with personal freedom, particularly for vulnerable groups and minority communities. As a result, the effectiveness of PACE does not depend solely on the wording of the legislation itself, but also on strict judicial enforcement, proper police accountability, and the willingness of the courts to intervene whenever police powers are exercised unfairly or unlawfully. Thank you for watching and good luck in your exams.